Admission? Huh? Motion. Next to next week.
There is a criminal revision petition, Milord. I am for the respondent wife, Milord. The Milord, we prepare for listing on the 30th, Milord.
No, next to next week.
Next
We're commencing from 4th August.
August, Milord.
It's also better, madam, state on 24/6. We can order, madam, please after 2 weeks. It's not-
Motion maker.
Also better.
Next week,
Monday, madam.
next week. Not Monday, already full.
Can you also-
List is prepared.
See, I beg to mention for court criminal petition.
So I think it's a listing of an IL or something regarding delay.
Next to next week. On a fixed date. On a fixed date next.
Petition also is the last one, April 24 also. On 8th of.
Okay.
Lordship, I beg to mention for listing a criminal appeal, Lordship, that the IA pending for consideration. That may be listed.
After 4th August.
Lordship, and another, they are Lordship item number 24 and 26. for the
Yes.
activities. It may be taken up at 2 p.m. Lordship.
2 p.m. this court is not sitting.
Then any other,
Wednesday?
next week.
Okay, on the pair of Mr. L.R. Modanbar and a counsel for the petitioner is the case on Wednesday. 24, same 26.
Of like,
Orders, new or old? Okay. Give the court master. We'll give that it in August.
Item number 17, Lordship.
Yes.
Lordship, we had a prayer to leave them around 2, but as the court is not sitting at 2, Lordship, the passover court will be.
Okay. Friday, next Friday? Okay, on the prayer of Mr.
Amen. Lordship.
A. Mina, Lani counsel for the petition, leave the case on so and so. Person. RJ Guru.
I beg to mention item number 14.
14
For a day, Lordship.
for the day.
For a day, Lordship.
Okay. Wednesday?
Lordship.
Okay, on the prayer of Mr.
I-
R.N. Sudhir, Lani counsel for the petitioner, leave the case on Wednesday.
May please, Your Lordship, I beg for listing of criminal petition, Your Lordship, on 8th of August, Your Lordship. Will be obliged.
I will still agree for withdrawal. On
When?
Monday, Lordship.
Next week? Next week only.
May please, I beg to mention item number 29 of supplementary list, passover for the day, Lordship.
29.
Supplementary list.
On the prayer of Mr.
Isla.
A. Islam, Lani counsel for the petition and the case is passport for the day. RJ Bolu. You have informed the other side.
Yes, Your Lordship.
Okay. Consideration taken from the Lani counsel for the respondent school.
Obliged.
So I beg to get to item number 12.
Well,
Take on adjourn this council is.
okay, Mr.
H. Brother.
H. Bro, Lani counsel for the petition, paying for the petition and wait for adjournment for the day. Consent. The price allowed later. The case is possible for the day.
Release from 12. Item 1.
My pleasure, Lordship.
Yes.
But this matter has been settled between the parties outside the. court.
Okay, Mr. H. A. Ahmed, Lani counsel for the petitioner has submitted that since the matter has been amicably settled between the parties, the petition doesn't want to pursue this criminal petition. So, any state is a party,
No,
state is not a party.
no.
Okay, in view of the above submission made by Mr. Ahmed, Lani counsel for the party, petitioner, the criminal petition is dismissed on 12. The interim order passed earlier is accordingly recalled.
Bless.
Item 2.
There is no representation on behalf of the petitioner today on call. Is the case come up for answer justice on next Friday? No, the case is for answer justice. Possible for it.
Item 3.
May I please, this revision is prepared by NCB challenging the order dated 34/2025. See, bail was granted in case of commercial quantity on the ground that ground of arrest was not explained to the petitioner named on the list. That is not correct, Lord sir. Lord sir, may I please to see the arrest memo. He put his,
Now, this is the raising controversy nowadays.
yes, Lord.
Okay,
What's if
where is
he,
the terrace memo?
arrest memo, page 29. Lord sir.
At this stage, we can issue notice on the
Not-
fixed date,
Yes.
returnable on the fixed date.
Lord sir.
Heard Mr. S.C. Kyle, Learning Council. For the petitioner, Mr. This single petition is preferred to a sale and order dated 30/4/2025 passed by the
Assistant Judge.
Honorable, passed by the Session Judge Kachar at Silsor. On a petition, petition number 1/1. Filed by the respondent accused seeking his bail in connection with NCB crime number 03/2025. First, Mr. Carl Leonard Classes, appealing for the petition has submitted that. The respondent number 2 was intercepted with 7.473 kgs of methamphetamine tablets on 13/3/2025. And on that basis, NCB crime number 03/2025 was registered. First of on the petition filed by the respondent number 2 as accused for bail, the learned Sessions Court granted bail to the respondent number 2 as accused by the order dated 30/4/2025, purportedly on the ground that the grounds of arrest was not served upon the petitioner. And in light of the observation made in Bihan Kumar versus State of Haryana and another 2025 SCC online SC 269. Post of Mr. Kyle has contended that by Mr. Kyle by referring to the memorandum of arrest within bracket annexer D has annexer C
Let us see.
has contended that the grounds of arrest were duly in writing were duly apprised to the petitioner under which is signature on it. So issue notice returnable. He is from which place?
He's from Manipur, Lord sir.
Returnable on. The petition shall take steps for service of notice upon the respondent by registered post duty within 2 working days from today.
May I please, Your Lordship.
Hmm.
It is against the denial of Jimma, the cash amount of the petitioner amounting to 22,70,000. And there were two,
What to do? Case record not received.
on the last occasion that was not received.
Lazy Bush Kent copy has not yet been received. That is,
It was called for long back. So
case record along with so and so has not been received by them.
My scan copy.
And report received.
Court December, then already investigation ended by the third submitted.
And in that case, you lost. The other, there were gold and gold was also seized from petitioner and cash. Gold already, this court has already directed, I have annexed the judgment also. That been already given Jimma.
Yes.
Cash is the same, your lordship, the same judgment which was followed in the case of the gold. That judgment of the Honorable Supreme Court also has stated how to be granted cash in case of Jimma given in case of cash also. Same judgment given. So I can.
Okay,
provide that.
another, Mr. Bangan will propose that on 4th of August we'll dispose of the TCR is not received.
Lots.
Heard Mr. Y.S. Manuel, learned counsel for the petitioner, and Mr. R.J. Borwal, learned additional public prosecutor for the respondent's stake. As per office note dated 22/7/2025, case record along with petitions filed by the petitioner has not been received till date. Post of office to issue a press reminder indicating that the case will be taken up on 4th of August 2025. Post of. It is observed that in the events, scan copies of the TCR as called for by order dated 28/5/2025, is not received on the next date of listing, the court may proceed for consideration of the petition without the TCR. Is the case on 4th of August.
He has already received the report also.
Okay, the report received by Mr. R.J. Borwal, Mr. Borwal, and additional public prosecutor is to be retained for placing it on the next date of list. Release the case on 4/8/2020.
That's all.
Item 5.
May please, Your Lordship, this is an application for crossing the circuit and enter proceeding.
Release the matter. Quashing of
Circuit and enter proceeding, Lordship, and the.
enter proceeding, where is the FIR?
FI space, Lordship, page 18 is the particular, Lordship, may I read?
Yes. Okay, let me read.
সন্মান সহকাৰে আপোনাক জনাও যে উপৰোক্ত আসামীজন মোৰ প্ৰতিবেশী গাঁৱৰ লোক হয়। আসামীজনে মোৰ স্বামীৰ সৈতে ধেমাজিত থাকি মাছৰ ব্যৱসায় কৰে। যোৱা ইংৰাজী 12/11/19 তাৰিখে ৰাতি মোৰ স্বামী ঘৰত নথকা অৱস্থাত
Yes, I have read. Yes.
লচিত
It is an offense under, according to FIR,
376
376.
yeah.
Yes.
There is a contradiction along with FIR and 164 statement. 164 statement 43 Lordship. Last portion actually.
43.
43 page number. 100 Lordship.
43.
মোৰ ঘৰ কুবেকটা মই মোৰ হাজবেণ্ড
Okay, let me read. Considering the offense, let me read. But at this stage, where is the question of contradiction?
Last part
This
is
should
the-
be overreaching the jurisdiction of 482.
and a medical report also not corroborated with the
That is a matter of appreciation. Otherwise, core allegation is, has remained intact.
Lordship,
That is a matter of appreciation. How can it be?
Lordship, I have another pair to recall the warrant of arrest, Lordship, because
That is a different thing, Mr.
Lordship-
Absolutely no case for washing.
Lordship, then he already shown an absconder, but he has not charged his business place, so he has no knowledge.
No, when the charge sheet was submitted.
Charge sheet, Lordship,
Sir, counsel, don't say when there is no case, absolutely no case for passing.
There's a
The,
contradiction.
this
Medical
is a matter of appreciation, maybe some exaggeration, but core story has remained intact. The core story has remained intact in the FIR as well as in the 164 statement. Then Sarsited.
Sarsited.
Then
Here shown as absconder হচ্ছে
where is the Sarsit?
Sarsit is a page 19 হচ্ছে
Page
19 হচ্ছে this is a
90,
19 19
19.
yes হচ্ছে yes Sarsit under section 376 and shown as absconder হচ্ছে and
90.
and petitioner also file a petition before the
19.
trial court to adjourn the matter for illness due to illness he could not appear on 9/1/2025 and he was issued
This was on which date? Submission of Sarsit.
appearance করছে
No, no. When it was submitted?
yes
Huh? 23. Almost 1 year, 10 months. Okay, then thereafter, when someone was issued,
order sheet was-
investigating official submitted charge sheet. Shown medical report. Case is made over. Cell 4-5. Summons. In absence,
Provisions
summons
taken
not issue a
page
place.
5.
Senior regulation. Is there BA? Come to page 38.
Yes, proceed. Yes, proceed. Thereafter on the 9/1 9/1 page 47 হচ্ছে page 47 হচ্ছে 9/1/2025 accused Babul Hussain is absent with step 5 petition number so and so causing cause of illness seen and heard the petition also seen the order dated so and so passed by the honorable district and session judge when the honorable court has directed the accused Babul Hussain to appear before this honorable court on date fixed apply for regular bail and the said court shall consider the same strictly in accordance to law to the accused did not appear considering the pair of petition number is rejected issue warrant of arrest against the accused. So we have paid for recall the issuance of.
It is at the stage of committal.
So I'm
Right, issue,
protected.
issue NBWA. If we also keep it under suspension, right, then the order dated 4/5/2024 will remain in force.
But if I humble prayer all the warrant of arrest and I may be allowed to appear before the trial court, just some protection may be needed.
Yes, there is a direction. We can keep the MBWA under suspension, but you have to appear.
Some protection. I have.
MBWA is suspension is protection.
Yes, yes.
What more protection?
And we could.
Oh, no, cannot be. It is for that. Yes, NBWA suspension within 2 weeks. He appeared before the. But you have to appear physically.
Yes,
You have to submit yourself to the jurisdiction of the court.
yes, sir.
Heard Mr. K.M. Swaikin,
কি বৰং?
P. Borala and counsel for the petitioner and Mr. R.J. Burua, learned additional public prosecutor for the respondent number 1, comma, state of Assam. Postal. The petitioner was named as the sole accused in a first information report lodged by the respondent number 2 as the informant before the officer in charge, Botador Police Station on 14/11/2019. Post on receipt of the FIR, the case, Botador Police Station, case number 348/2019 was registered for the offense under section 376 IPC. Post. In the course of investigation, the informant respondent number 2 was medically examined and a statement under section 164 CRPC was recorded. Postal. After recording statements of number of witnesses and completing other formalities, the IO completing the investigation, submitted a charge sheet under section 173 CRPC by charge sheet number 121 of 2023 on 13/39/2023 in connection with Botador Police Station case number so finding a perhaps the case for against the petitioner for committing an offense under section 376 IPC. So in the charge sheet, the IO mentioned that despite approach the petitioner could not be found. Postal. On submission of the charge sheet, before the Court of Learned Judicial Magistrate Nagaon, the state court as the committal court. Registered the same as police report case PRC case number 493 of 2024. Postal. After taking cognizance under section 376 IPC on 10/5/2024, the court issued summons to the petition as the sole accused. Postal. As the petitioner did not appear, the summons were not okay. During this case, the petitioner preferred a bail application, bail application number 1827 within bracket N stroke 2024 before the Court of Learned Additional Session Judge number 1 special judge within bracket POCSO Nagaon for his pre-arrest bail. Postal. The said application was disposed of with a direction to the petitioner to appear before the Court of Learned Chief Judicial Magistrate Nagaon on the date fixed and to apply for regular bail. Postal. It was thereafter, a petition, petition number 126 to 2025 was filed on behalf of the petitioner before the Court of Language Chief Judicial Magistrate of Nagaon, showing taking a ground sorry, on behalf of the petition. Also, in the petition, the petitioner showed that he had to be absent because of illness. Also, after hearing, and taking note of the direction made in the order dated 26/11/2024 passed by the District Administration Judge number 1, Nagaon. The prayer made in the petition was rejected in view of non-appearance of the petitioner posted by an order dated 9/1/2025. Posted by the order dated 9/1/2025, the Court of Landed Chief Judicial Magistrate Nagaon also issued warrant of arrest against the petitioner, fixing the date, 24/3/2025 for his appearance. Posted. On to 24/3/2025, court taking order for issuance of NBWA. Posted, hence the criminal petition. Posted, though a number of prayers have been made in this criminal petition, the counsel for the petition has confined his submissions on the orders issuing non-bailable warrant of arrest by the Court of London Chief Judicial Magistrate on 9/1/2025 and thereafter. Posted. Mr. Learned Counsel for the petitioner has submitted that the petitioner is ready and willing to participate in the trial. And because of the issuance of no warrant of arrest, the petitioner is apprehended that before his appearance, he might be taken into custody. Posted. Mr. Burwal and Additional Public Prosecutor appearing for the husband number 1 still submitted that if the petitioner is ready and willing to participate in the client, the same, the trial, the same would facilitate an expeditious adjudication, expeditious completion of the trial of a charge which is otherwise serious in nature. Posted. As the petitioner, or the petitioner is facing its charge under section 376 IPC. On submission of the charge sheet on 39/2023, posted. Whether there are sufficient materials or not to frame a charge under section 376 IPC is dependent on the sufficiency of the materials. Most of the charge is yet to be framed against the petitioner and because of his non-appearance before the trial for post of the case is yet to be committed. It is a session tribal. Case is yet to be committed to the court of sections. Post of. There is already a direction to the petitioner to appear before the court of learned chief judicial magistrate Nagaon. Post of. As the petitioner is ready and willing to participate in the trial and the same would facilitate an expeditious trial, this court, is of the considered view that for securing the ends of justice, the warrant of arrest issued against the petition on 9/1/2025 and thereafter by orders dated 9/1/2025 and thereafter can be suspended for a period of 2 weeks to enable the petitioner to appear before the court of learned chief judicial magistrate within the said period. It is ordered accordingly. The petition shall appear before the court of learned chief judicial magistrate Nagaon within a period of 2 weeks. And in the event, the petitioner submits any application for his bail, the same shall be considered as per its own merits and in accordance with law. So it is part of that in the event the petitioner fails to appear within a period of 2 weeks from today, the warrant of arrest issued against the petitioner will stand revived.
Hello.
With the above direction and observation, the criminal petition is disposed of.
6 and 7.
May it please your lordship. So the issue here is regarding the extension of period of detention beyond the statutory period. Under the scheme of the NDPS Act, like my lord, in the case of TADA and UAPA, it can be extended under 3 years of the PP, my lord.
PP, yes.
But only thing is that the requirement of law, my lord, is that
43,
43D D in case of UAPA, 36(4)A in case of
36 Okay.
But then the accused has to be put to notice, my lord. He has to be given an opportunity of hearing. That was not done here, my lord. The lordship
Yes, Mr. Borua. How to proceed?
Where is the provision, my lord, that my learned friend so, my lord? Is there any provision that while, my lord, the public prosecutor waits for time, my lord, for extension of the investigation, my lord? Is there any requirement of, my lord, law, under the law, my lord? And notice has to be given, my lord.
Yes.
So this is the, my lord,
Maybe by jurisprudence.
settled, my lord, since within the national.
If the during investigation, my lord.
It is always done. Investigation is to be, prayer is that because so and so reason, the investigation could not be completed within a prescribed period. So, a petition is to be filed, moved by the PP for extension, showing reason. And in the meantime, otherwise, he is going to get default bail. That issue will require some examination. There are, I think, precedents. No provisions. Something is read into the provision. No, Mr. Borua, if it is something has been read into the provision under 140, Article 141, that is also binding on you. You cannot deny. You go through this. Examine if it is notice is to be given. Because one right of the accused is intertwined with the petition. If the petition is not allowed, he has the right to go on default bail. If the petition is allowed, then he has to move his application for bail on merits. Default bail, no merit. I think this is the,
That is the dichotomy, my lord.
so the interconnection. And if the IO moves, that is, I don't think that is the law. It is the PP who has to, it is Mr. Borua who has to reach the satisfaction and show in the application his grounds of reaching the satisfaction why the period of investigation should not be extended. Thereafter, application of mine by the court, but it is a PP. It is not that IO has given this application.
IO has to exercise the fact the public.
For that, Mr. We have to, I think, get
Records
the
have
scan
already-
copies.
Records have already come, man.
Okay, good enough.
Take them. Because
On Thursday? You were there, so we'll issue short notice, returnable Thursday
Yes.
or not Thursday. Many cases have been already fixed. 5th of August or 7th of August?
as per the law, sir.
5th of August. Or 7th? Thursday?
7th of August.
7th. Okay. As here also this year.
Okay, give it. Sanjay Kedia, I found
Which is the impugned order?
impugned order, my lord, will find at page 41, my lord.
Your ground is that you should have been put to notice.
Put to notice.
This is the only
This
ground.
is the only one. We are not challenging the.
Only
sufficiency.
this. You
In
should
fairness-
have been put to notice
Notice,
that an application is being moved for extension of the period of investigation. Yes or no? If the law laid down is that yes, yes.
two requirements, my lord. Vishnu Thakur initially said that I have to be put to notice. Constitution bench and Sanjay Dutt said that written notice is not necessary, but I have to be physically produced before the court and I have to be heard.
Okay,
Neither of these was done.
okay. Heard Mr. S. Nawaz, Learned Council for the petition, single petitioner,
Single petition.
and Mr. R.J. Burua, Learned Addition, Public Prosecutor, but the respondent. State, first up. The petitioner hearing has been arrested in connection with Nagaon Police Station, case number 1156/2024, which has been registered for the offences is 38%. Under section 61(2)/123, BNS, read with section 21(a)/25(27) NDPS Act with added section 21C, meaning thereby commercial,
Commercial.
NDPS, meaning thereby to American. The petitioner in this criminal petition has assailed an order dated 3/6/2025. Which is an order passed on an application seeking extension of the period of investigation beyond 180 days under subsection 4 of section 36A of the NDPS Act. Postal. Para Mr. Nawaz, Learned Counsel for the petitioner has contended that petitioner has been denied an opportunity and the stage of moving the said application. First of, the order dated 3/6/2025 was passed on a date when the petition was not brought before the court. Correct? Full stop. He has further contended that the petitioner was not given notice about the application file for extension of the period of investigation. Full stop. Para.
Full judgment.
He has referred to the decisions of the Honorable Supreme Court of India in so and so to buttress his submissions. The matter would require consideration. The TCR has already been received. Issue notice returnable on 7th of August. Just the endeavor will be made to give final consideration to the cases on the returnable debt. Both the matter.
It is the bail matter.
If criminal petition is allowed, I think bail petition.
That will be some structures.
Why?
Name the criminal petition, the item number 7.
Okay.
I'm deep. No judgment be kept in the record. Deep level. Item 8. It also worried a hard.
Joseph, in this case, also. Is a maintainable?
Yes. Appellate remedy is available. What do you say?
In this case, subsection 2, Lordship, it is a, again, some order ordinary lie conviction by magistrate means for the trial. If I not,
Which one? I've said BNSS.
if I please guilty.
CRPC.
you'll be liable to
Which one?
subsection 2. 50.
Where is the question of guilty?
Yes, Lordship. Only Lordship not received a chemical reports, my petition was rejected, Lordship. But
No.
I-
That was gone.
yes, Lordship.
That was followed by a subsequent order. That is,
Within 6 months, I have.
you
filed-
did not challenge that. Which one you have challenged? Let us see the prayer 16/11/2024. You have challenged. That is beyond limitation now.
27.
That is beyond limitation. Then 27/3. Is it not?
Yes, Lordship. 27 and 16, 11 and 20.
Subdivision, you have to prepare an appeal. This is absolutely in conformity with law.
They have said they're not fit for.
An
criminal conviction.
appeal shall lie
Yes,
against any order to the court to which ordinarily appeals ordinarily lie from convictions by the magistrate, meaning thereby the same forum,
thank you.
not after conviction. Have you understood?
Yes, Lordship. That's why learning stage, Lordship. As per my knowledge, Lordship. it's
So-
very-
The same appellate forum where an appeal lies from an order of the magistrate will be the appellate forum for this kind of appeal under section 458. That is all it has indicated. Conviction is not to be recorded at any stage. It is regarding procedure when no claimant appears within 6 months and where the order has been passed for public auction. You prefer, it has not been auctioned? It has not been auctioned.
So, but my submission only, Lordship, they have not taken evidence my ownership. case.
One clever man,
Only for the chemical.
one clever man, what he did.
Another date also, Lordship, for the chemical reports. In subdivision, Lordship, my submission only that's Lordship. They have not my evidence, Lordship. I am not a ownership.
Mr. Rangme, in this page 28 order, you were absent.
No.
Page 28 order. Show your presence in the order.
27, 3, Lordship. 27, 2025.
Yes. One clever person, what he did, he participated in the auction, gave the highest bidding, got the auction. Thereafter, his appeal was allowed. He got both back. You file an appeal.
You know, direction was
Huh?
direct with the direction.
Direction of appellate forum is available. Specific remedy of appeal is available. Huh? There is no. Is there anything? Specifically, no. Huh?
Number 27. He's claiming the ownership of this particular American army.
Yes,
The purpose of this-
which is not fit for human consumption.
That is the after the.
It is also not clear, Lordship. in the-
You go, the appellate forum can go through everything.
Kindly see my lord, page number 27 and answer 6. This invoice my lord generated on 15/7/2022.
And date of seizure,
Page number 16 is the FIR.
page number 16.
Same day seizure.
Huh?
Same day seizure.
Page number
16.
date
13.
1310. So this is under section 127 or 129 GST. This is another offense. Before the appellate forum. Heart. Miss R. Rangman, Land Council for a petition, and Mr. R.J. Borwa, Land Additional Public Prosecutor for the respondent state was some. Those two. In connection with Lockheed Police Station. Case number 160/2024. Consignment of Erekanat. Weighing. Contained in 465. Weighing 26,905 kg was seized by the serial list, MI number 156/2000. On only two question, on 14/10/2000. The FIR was lodged by a sub-inspector of police. Okay, 13/10. Sorry, 14/10. The FIR was lodged by a sub-inspector of police attached to Rockybrook Police Station on 13/10/2024. Pursuant to Rockybrook Police Station, General Diary entry number 20 dated 30/10/2020. Question. The sex of Erika Knox were seized from one Wagoner, one vehicle, Wagoner bearing registration number AS-11/X-32AG. On 13/10/2020. And two persons, namely, A16, Dilwar Hussain Mustafa and two Mustaka Ahmed Tabakar, were occupants of the said vehicle. The petition was is the registered owner of the said seized vehicle. And on the petition sought custody of the said seized vehicle by filing the petition, the court of learned subdivisional judicial magistrate within the and Lothipo Kachar by order dated 16/11/2024, granted custody of the seized vehicle subject to execution of a bond of the amount mentioned in the order and other conditions of the amount and the terms and conditions mentioned in the order. Another petition was preferred by the petitioner for custody of the seized Erika Knox before the same court. By the same order dated 16/11/2024, the learned SDGM M. Rockybrook Kachar rejected the prayer for custody of Erika. Subsequently, the IO of the case moved in petition. Sorry, the officer in charge of Rockybrook Police Station moved a petition in connection with Rockybrook Police Station case number 160/2024. Indicating that the Erika Knox weighing 26,905 kg seized by the MR number 1562 2024, was lying in the police station compound, and no true owner could be found. Also, since arecanut is a perishable agro product, the officer in charge of Wakipur police station stroke dive sought permission from the court to sell the seized arecanuts through public auction and to deposit the proceeds from the auction to the state exchequer to prevent the arecanuts from further damage caused to Para. By an order dated 27/3/2025, the SDGM M. Wakipur Kachar in connection with PRC case number 19 of 2025. After consideration, after examination of a physical verification report of the district agriculture officer Kachar, a report submitted by the State Public Health Laboratory, paper publications made in widely circulated newspapers in 2 languages, and other documents available on record, allowed had reached a finding that the arecanut so seized and lying in the police station premises, was not suitable for human consumption. First of all, the land SDGM and thereafter directed to conduct a public auction under the supervision of the District Disposal Committee for arecanuts and deposit the sale proceeds of such auction in the refundable fund of the state treasury to ensure fair disposal of the seed goods. And also in the order dated 27/3/2025, the SDGM of People has further observed that if any true claimant appears thereafter, the such claimant can be reimbursed to stop. The instant criminal petition is prepared by the petitioner to assail the orders, dated 16/11/2024 and 27/3/2025 on the strength of a what is that? Consignment note on the strength of an EA bill. Annexed as Annex 6 to this petition. First of it is the contention of the petition that he went to Lakshipur police station for release of his seized arecanut, with the said E-way bill. But the police station refused to hand over the same to the petitioner without any order from the court. Full stop. Para Mr. Borua, Learned Additional Public Prosecutor, has contended that the e-way bill was generated only on 15/10/2024, that is, after the seizure of the Arakan nuts weighing 26,905 kg. Those were the e-way bill in view of apparently, it appears that the e-way bill, on the strength of which the petitioner has claimed the ownership of the seized Arakan nuts, was generated on 15/10/2024 within bracket Annexa 6, which is a date much after the recovery and seizure of 26,905 kgs of Arakan nuts on 13/10/2020. First, para. Raising disputed questions of fact. First, para. The order dated 27/3/2025 has been passed by the Learned SDGM M. Bhaktipur Chief Kachar. Apparently, under subsection 2 of section 450, sorry, not subsection 2. 520, 450, 504. Under subsection, under section 504 within bracket 2, Bharatiya Nagorik Suraksha Samhita. Oh, no. 50. 504 BNSS subsection 1 of, so 504 within bracket 1. Comma, within bracket, earlier, comma, section 458 within bracket 1, CRPC. Full stop. A specific remedy of appeal in such a case is available under subsection 2 of section 504 BNSS within brackets earlier under subsection 2 of section 458 CRS. As in an appellate jurisdiction, the appellate court can go into to decide both the questions of facts as well as law. And there is disputed questions of fact involved in this case, a dispute is of the considered view that the petitioner shall avail the specific remedy of appeal available to him under section 504 within bracket 2 BNSS 2023. Made earlier, section 458 within bracket 2 CRPC. First, to establish his claim of ownership of the seized Arakanat wing so and so kg. So as the ownership of as the claim for ownership of the seized Arakanat wing so and so is to be decided is in doubt. So much. I don't know, this court does not find any merits to entertain this petition under section 528 RBNSS. Therefore, this petition is dismissed, reserving the liberty to the petition to avail the remedy under section so and so of the BNSS. First of all. Finally, is contended on behalf of the petitioner that the public auction has not yet been taken place.
Number 9.
My please, Lordship. Lordship kindly pass over the day, Lordship. The engaged councillor, Lordship, due to illness of engaged council, so he could not come, your Lordship.
Okay. On the prayer of Mr.
As Islam, on behalf of
As
AIB.
Islam Learned Council, appearing for a petition, the case is passed for the day.
Yes.
Motion 520 BNS application, Lordship.
528.
BNS application.
Yes.
Lordship. This petition has been preferred due to not consideration of the petition preferred by the petitioner at page number 17, Your Lordship. Before the special just POXO court Nagaon, Your Lordship. This petition has been preferred for Lordship recalling of a victim, Your Lordship, and for the examination of a victim in a POXO proceeding, Your Lordship. And that petition has not been even considered, Your Lordship. And the Planet Trial Court asks the engaged counsel to not place the petition, Your Lordship. So accordingly, the petition has been not placed, Your Lordship.
Then
Yes,
not praised,
no order has been passed.
not praised. Why did you agree to not praise?
Your Lordship, because the trial court even not agree to, Your Lordship, admit this petition, Your Lordship. Already petition number is there, Your Lordship. Petition number is there, Your Lordship, but the Rani trial court said that not any cost, I'm not going to admit this petition, Your Lordship. So, Lordship, for that reason, Lordship, actually what happened, Lordship? On 18/6/2025, during the trial, Your Lordship, pendency of the trial, already most of the
1 minute, what is the case?
Lordship,
What is the trial?
it's for examination of I.
What is the case number?
It is 2025, 20.
What is the
Lordship.
FIR? This is the FIR.
Lordship.
When it was lost? 14,
14/9/19, Your Lordship.
14/9/2019.
Victim has already been examined, Your Lordship. Her, it is at
When she was examined,
20, Your Lordship,
Hmm?
page number 20, Your Lordship.
18/9/2023. Okay, then how many witnesses were examined?
Already all of the witnesses have been examined.
All the
IO,
witnesses were examined.
I for IO, Your Lordship, no. pending for IO
Wherever is
consideration.
my will pending your trial. Privacy, I am in agreement with the learned trial court.
Chairman, because
Only the cost is to be determined. For trying to delay the case. FIR was of 19.
Lordship,
Victim was examined in 2020.
23.
Almost all the witnesses were examined. Only the IO is to be examined as on date. Then after 6 years,
Lordship,
a so-called public meeting was held. Something transpired there and victim is to be recalled. That is the prayer under section 311. So no question for entertaining this kind of petition. And learned trial court, not to cause prejudice, had asked you to not to press this petition, not to prejudice the case of the accused, perhaps. Despite that, because the discretion is to be exercised by the learned trial court, under section 311, right? For just decision of the case. If the court feels that a witness is to be recalled, right? And there is no provision in the Evidence Act. Examination in chief, cross-examination, and if re-examination, then further cross-examination. Where is the question without re-examination for further cross-examination?
because your Lordship, 18/6/2025, your Lordship.
Dismissed to be in limine. And if you want to adduce evidence, you have the opportunity to enter into the witness box or to adduce the evidence of Gamura.
SDW.
Yes, as DW. It is not abusing the process of the court. Privacy, it looks like,
Otherwise,
and to fill the lacuna,
otherwise, your Lordship.
Heard.
because-
no question. Rightly. Extensively cross-examined. Cross-examination is more wise than the chief examination. What more? Heard, Miss G. Bora. Yes, Miss. There is no order of the trial court also. Where is your statement? Where is your statement that this has been made to withdrawn?
Yes, Lordship.
Whether trial court gives such advice?
Yes, Lordship.
Where is your statement? It is a completely wrong statement. The trial court insisted for withdrawal of
7,
absolutely wrong statement.
7. 7, your Lordship.
So where is the order? Where is the order?
Order is not there, your lordship. Ordinarily, the youngest counsel not placed the petition, your lordship. There is no order, your lordship.
Yes, Mr. Buddha, if a petition is not placed, what is to be done? An order? No order. Huh? Not placing that petitioner is not placing this petition.
But, lordship, can you see petition number is there, your lordship?
Yes, Bora, don't play such with words like this in paragraph 7. I am cautioning you that learned trial court would not accept such type of petition at any cost. As such, the learned counsel for the petitioner not raise the petition has preferred this criminal petition. Don't make such aberrations. You will be at fault. Heard Ms. G. Bora. Learned counsel for the petition. And Mr. R.J. Bora, learned additional public prosecutor for the response state. First. This criminal petition under 528 Bharatiya Nagarik Act is preferred to assail to allow the petitioner to re-examine, cross-examine the victim on behalf of the petitioner who is standing in a trial of special POCSO case number 25/2020, presently pending before the court of learned additional session just come special POCSO judge, as the sole accused. First of the case, special within bracket POCSO case number 25 within bracket N stroke 2020 arose out of an FIR lodged by the father or the victim as the informant before the officer in charge, Uluwani Police Station on 14/9/2019. Post of in the FIR, the informant had entirely alleged commission of an offense under Section 4, protection of children, so POCSO Act. Post of the FIR was registered as under Section 4 POCSO Act, read with Section 376 from IPC. Post of the consequent investigation resulted into a charge sheet. Post of on submission of the charge sheet, the case has finally been registered as special POCSO case number so and so. Post of the trial, after framing the charge, the trial had proceeded before the court of learned special judge POCSO Nagaon. Post of from the materials on record, it has emerged that the victim was examined as PW1 on 18/9/2023, and on the same date, the victim was examined in detail, cross-examined in detail by the defense. Post of it has further emerged that testimony of about 12 prosecution witnesses have already been recorded. And the trial is at the last stage of recording evidence, as only the investigating officer IO is left to be examined. First of Tara. A petition was moved at that stage by on behalf of the petitioner accused before the learned trial court, before the learned special court, seeking where is your petition?
17, Your Worship.
Seeking an order for re-examination of the victim and also to examine a Gaon Pradhan or Gaon Buddha
So now it is
Gaon
Gaon
Pradhan
Pradhan.
of a particular village, a village, Hokowamari, police station, Uluwani, Posto. The grounds on which such re-examination, further cross-examination of the victim and examination of the Gaon Pradhan has been sought for is a meeting stated to have been held on 18/6/2025, wherein the victim and the Sikh Gaon Pradhan had participated. First of all, the contention of the petitioner is that in the said meeting, the victim had stated something which indicated that there was some misunderstanding between the victim and the petitioner. First of all, para. The the examination chief, cross-examination, so on. Whereas, insofar as the examination of Gaon Pradhan of so-and-so village is concerned, the said person is not a listed witness in the charge sheet. So, as such, the prayer for his examination or his examination and his stage does not appear to be in conformity with Section 137 of the Evidence Act. Also, the examination of the victim was already over on 18/9/2023. First of all, on 18/9/2023, the defense had thoroughly cross-examined the victim. First of all, the meeting which was purportedly held on 18/6/2025 was not a matter which evidence is essential for the just decision of the case. Question. The petitioner has the opportunity to adduce evidence of the Gabardhan as a defense witness. Question. Where it is found that if any petition is was moved, if any petition like the petition annexed herein as annexer three was moved before the line special court, there had to be a judicial order on it. But no such order has been annexed by the petition. The affirmance made in paragraph 7 of the instant petition cannot be appreciated in the absence of any material to support such affirmation. Having found no merit in this petition, the criminal petition is dismissed. What I personally use. Huh?
Sorry for late, my lord.
Yes,
My lord, this is maintained my lord, and application under section 528 of the BNSS. My lord, in this matter, my lord, praying for quashing and setting aside the case number Bazari Park PS case number 92 of 25, my lord. My lord.
on what ground?
My lord, down to that is case number 6, my lord.
No, where is the FIR?
FIR, my lord, case number 10, my lord.
Page number 10.
10, my lord, yes.
Who are you? Moinuddin Hawan Abdul Haq. Okay. Are you named in the FIR?
My
Huh? Are you named in the FIR?
lord, informant name is
Huh? 2, 4, and 5. This one is person. I was married.
regarding the
Bhagwan.
FIR, my lord. Information was
This is relation. It's use number 3. As I protest, one started torturing me, with my consent. Now, cyber inmates. Protesters attempted to kill me. Tried to as they're begging, as they're saying, get all the villains went on to the house action. So what is 10935? BNSS. BNSS control. BNS. What is 109, sir? No, I can't. BNS. BNS also, IPC, IPC. What is C5? 120B is C5 now. C5.
When a criminal act is done by several persons. In
Union bracket 5.
furtherance of the common intention of all, each and each such person is liable for that act in the same manner as if it is were done by him alone.
Okay, this is 34 or what?
34.
Okay, 34. Accused person. Where is the search sheet, sir?
My lord,
Huh? Oh, investigation is
my lord.
pending.
regarding the informant, she was married on 23/6/2025,
20
my lord. After the marriage, she come to know regarding the affair, my lord.
Forwarding report.
Accused number 1 and
Yes,
accused number
accused
2.
has been
Accused number 1 and
By which order you are?
has illegally relation between
Huh?
them, my lord.
Huh?
Regarding the affair, my lord, informant, she was married 23/6/2025, my lord. And after the marriage, she come to know regarding the affair, my lord. Accused number 1 and accused number 3 has illegally relationship between them, my
That
lord.
is a content, you are,
My lord,
you have been named in
in
the
fact,
FIR, right?
In fact, accused number 3 already died about 3 years back, my lord.
Huh?
My lord.
I'm not, I don't understood what he is saying.
And she has been made in accused falsely, my lord, by the informant.
Number 1 final.
Who made it?
Informant.
Informant. Informant is one Sipara, yes. He married to whom?
Petitioner number 1, Zakir Hussain.
Zakir Hussain.
The accusation already bailed, my lord.
After that, my lord, she came to know that her husband, my lord, is having illicit relationship.
Ah, yes,
Accused number
all this. Then the circulation of photographs,
Then, my lord, that
videos,
husband-
or whatever.
My lord, it was
Ah.
circulated, my lord.
Then
And
there
she
is an
had-
averment attempted to kill me.
attempted to kill me, my lord, that is in paragraph.
Ah.
my lord,
Then kept all my children, drove me
paragraph
out.
number second paragraph.
I saved my life by begging the same.
All accused person, my lord, untightly attempted to kill me and
Yes.
I take clothes around my neck for which
Ah.
I saved my life. My lord, then after, my lord, our father took her back.
Ah.
This is the allegation in the affair.
Yes.
Now the investigation is pending, my lord.
Yes.
Now they have come, my lord, for crossing of the, my lord, affair. It's a matter, we can call for the case that we can. So, my lord, accused number 2 is the mother, my lord, the mother of the, my lord, accused.
Absolutely nothing here.
4 and 5, my lord, would not know, my lord.
Absolutely nothing here. What is there? Except the FIR.
So the case is closed.
No, we'll see on another date. Mister, you satisfy me. I am not satisfied. Cannot get satisfaction. On next Friday, come up with better submissions. We have to see the contents of the FIR for passing. That's all.
Private.
We are not examining the veracity of the statement, whether the statements made in the FIR makes out a case and contains the ingredients of the offense alleged. That's all. That is what Bodlanath says. On the prayer, Mr. What your name? What is your name, please?
I
R.
will.
This is the case on next Friday. We'll decide. Welcome.
orders, Lordship. Here, we have filed this petition on the some law points as well as on the facts, Lordship.
Law points.
FIR is at page 20, sir, Lordship.
Hmm.
The gist of the FIR is that MLA Goripur in the year 2018, while inspecting some developmental works in the Debitola development block,
Hmm.
he has physically assaulted the block development officer, and block development officer filed the FIR by naming the MLA only, Nizanur Rahman. During investigation, police has added some section under Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act that has been allowed. And after completion of investigation, Lordship, in the year 2023, charge sheet has been laid by the IO.
Hmm.
The charge sheet is at page 31, Lordship.
Yes.
Particularly, that charge sheet specifically mentions, Lordship, at page 44, Lordship. It has been laid against 8 accused persons.
Hmm.
That is the present 7 petitioners and the MLA, who is not before this court, Lordship, as on today.
Hmm.
Upurot, Echo 147, 341, 353, 323, 427, 506 IPC, added section 3 R S U of SC and ST Prevention Atrocities Act, ধারা আংশিকভাবে অভিযোগপত্র দাখিল করল।
Hmm.
That is unheard of the CRPC system, PNSS system.
Hmm.
আংশিক charge sheet.
Hmm.
On this charge sheet, Honorable CGM has transferred the case to additional CGM. And by order date 19/4/2024 at page 47.
Hmm.
Additional CGM has taken cognizance of the offences
Hmm.
under section as mentioned in the charge sheet,
Hmm.
including SC and ST Prevention Act. At this stage, Lordship, I would like to pose that for the trial of SC and ST Act, Lordship, Government of Assam has constituted special courts. There is a Government of Assam notification, Lordship, constituting special courts.
Okay.
The special courts are the courts of sessions. It is under section 14. Government has constituted the special courts. Section 14 special SC/ST Act reads like, for the purpose of providing for speedy trial, the state government shall, with the concurrence of the Chief Justice of the High Court, by notification in the official gazette, establish an exclusive special court for one or more districts.
Okay.
Section 2, Lordship,
Hmm.
defines the special courts. D2D, special court means a court of sessions specified as a special court in section 14.
Hmm.
After amendment of 2016, Lordship, a provision has been added, provided further
But
that the-
that's 10 character, I think, next page, page 48. On perusal of the, I find no forensic material to presume commission of the offense.
that's why I'm coming on that point, Lordship. Here, the magistrate cannot take cognizance of the offense under once an SC/ST Act has been put in the charge sheet, Lordship. It is like a post office, Lordship. He has to transfer the entire case record to the special court, that is the Court of Sessions. Magistrate has no power to take cognizance. Even cannot consider, then thereafter, we have raised this objection when we have been received summons, charge hearing has been made, we raised this objection, but in spite of that, Lordship, offense has been explained by deleting that part that is beyond the inherent jurisdiction of the magistrate, Lordship. It is the special court who has to deal with.
Okay.
Then
Then,
the facts, Lordship, police
then
is
why you have prepared revision?
challenging this part of the framing of charge, Lordship. On the facts, I am coming, Lordship. Out of during the charge sheet, police has mentioned 16 witnesses, Lordship. Out of whom 11 are independent witnesses, including the informant. None of the witnesses have named these 7 petitioners, either as a associate of the MLA, the charge sheeted FIR named accused.
For that purpose, we need 161 statements.
Yes,
To examine that aspect,
That's-
we need
that's
161
definitely,
statements,
definitely, Lordship.
right? Otherwise, it is very difficult.
Yes, Lordship.
Now, the remaining, there are 2 aspects to it.
Lordship.
Are you challenging this taking of cognizance by this? Or you are happy with the removal of the offenses under SC/ST Act? There are 2 ways to look into it, right?
Lordship.
Otherwise, your contention has been, so far SC/ST Act is concerned, that has been removed. Yes, maybe
Lordship.
that court could not have taken cognizance,
Yes,
could not have the power and jurisdiction to decide on any matter under the SCST Act.
Yes, Lordship.
But by the subsequent act, rightly or wrongly, those were removed.
Yes, Lordship.
As on that, there is no SCST offenses under them, right? And what the criminal revision is about?
That on factual aspect, we have not been named by any of the
No,
witnesses.
that is a matter, that is a
That,
different issue.
let's say that's why I'm saying admit.
There are
this
two
petition,
aspects to it.
Lordship.
One is regarding SCST. Offenses were added by the IO
Yes, Lordship.
and search sheet was submitted. Then according to your contention, it is the special court which should have taken cognizance of it,
Yes, Lordship.
right? But somehow or the other, by the two orders, at the end of it, this SCST offense charge under SCST Act were removed.
Yes,
So
Lordship.
are you concentrating on that?
No.
Or now you are
No,
concentrating on
other IPC offenses also, Lordship.
IPC offenses that no
We have
offenses
not-
are made out.
Yes, no cases against us.
For that purpose, we need to examine the 161 statements.
Yes, Lord.
For that purpose.
Yes, Lordship.
Now, it can go in two directions. If you challenge this 19/4/2024 and 5/9/2024 orders, then we'll first concentrate on the order, authority and jurisdiction of the learned additional chief judicial magistrate to decide or exercise his power on it about taking
Yes,
cognizance
Lordship.
or removing the offenses.
That is one aspect. Lordship.
That is one, right? And secondly, the next part, the remaining offenses.
Remaining part. Lordship.
Remaining offenses, I think, what are the offenses?
This IPC offenses under Lordship.
IPC offenses under,
147, 341, 353, 506.
where is that?
At
5/9/2024 order.
48, Lordship.
48 page 48.
The 147, 341, for which offenses have been explained against us, Lordship.
Hmm.
We have challenged this also. There is no material against us.
Then you challenge this order.
Yes. Charge sheet, even there is no material in charge sheet, Lordship, for submitting charge sheet.
Question is 5/9/2024 order has been challenged in the criminal revision before
Yes.
the,
That has been rejected, Lordship.
that has been rejected.
That's why we are before this court, Lordship.
So the question of merger is also there. That is why I am asking. So should I decide on the aspect of the charges under SCST Act or
Both, Lordship.
no, because revision petition, what is your prayer there?
Crossing of the charge sheet, Lordship. FIR and the charge sheet. If that goes, everything goes, Lordship. Because there is no material to submit charge sheet against us. That is our contention, Lordship.
So 207 stage is over already,
Yes, Lordship.
is it not?
Yes, Lordship.
Now, do you have the copies?
Yes, I have the copy.
Do you
Lordship.
place those copies?
No, because these are the not clear copies. That's why, Lordship, we call the scanned copies, Lordship, of authenticated to the charge.
Or
sheet.
otherwise,
I have the copies, Lordship, with me.
can you
None of
translate
the
it?
witnesses have named me,
Can you translate it?
Lordship.
Can you translate it?
I need some time, Lordship. There are 16 witnesses, Lordship,
16.
16. And next date is fixed on 30.
You furnish a copy to Mr. Goswami. Goswami, a copy. And if you, after going to Mr. Goswami, the statements, the relevant witnesses will read. If from their statements, if no offenses are made out, then we'll decide.
Lordship.
I think that will be otherwise calling again.
Okay, Lordship.
We do not know
Next date
now.
is, Lordship, on 30th 7, Lordship, for evidence, for cross-examination. So I humbly pray for stay of the further proceeding, Lordship. So far against the 7 petitioners.
Page 56.
Because trial is going on at
No,
least.
what is the revisional court has held?
Page 56.
Page 66, 56.
Is 56.
So, there are 9 of the review. Category.
Hmm. It is there, page 9.
No, Lordship,
Can I-
that is there, Lordship. That's why we have come before this court, Lordship.
So we have to reach a prime satisfaction about that.
No, but Lordship, trial is going on without jurisdiction. My point is that, Lordship.
No,
Addiction
that is
should-
gone.
No, magistrate has no power to even consider that, Lordship. No power even to consider. Once, like in a POXO case, Lordship, once IO put a charge of POXO in the charge sheet, a magistrate cannot take any cognizance. Like any other special offences where special courts have been constituted, Lordship. Even if evidence is recorded, Lord, that is beyond jurisdiction, inherent
No,
jurisdiction.
Now evidence is recorded for IPC offences.
Yes, Lord.
So far IPC offences are concerned, that court has the jurisdiction
Yes, Lordship.
to proceed with the trial.
Yes, Lordship.
The SC/ST offences have been removed. Maybe without the jurisdiction, but question of prejudice. Because anything is also related to prejudice.
Lordship.
Now that stage is gone. Now whether it is an illegality under 464 or irregularity 465, we have to examine.
No, that's why I'm paying, Lordship. that it
So
may
far
be
as
paid at-
For charges under IPC offences, whether case is made out or not, that has to be, for that purpose, we need to examine the 161 statements.
That is absolutely right, Lordship. But even
You
if
give a copy, we'll put it on Tuesday, we'll examine.
it is on next date is on 37, Lordship, because it is for cross-examination of the PW witnesses, Lordship. Already on the last date, we have been, I have given a copy, Lordship.
Okay, 29, we'll put it on 29.
Lordship.
29.
Yeah.
You go through it,
Lordship.
whether the statements made in paragraph, findings recorded in paragraph 9 by the revisional court is correct or not, that is the only issue.
Within 1 hour.
Heard Mr. S.K. Poddar, learned counsel for the petitioners, and Mr. M.P. Goswami, learned counsel for the learned additional public prosecutor for the respondent number 1 state, respondent state. Postal. Respondent number 1 state of some postal. As I sought for and agreed to by the learned counsel for the parties, lays the case on Tuesday. In the meantime, you hand over a copy of the 161 statements.
Obliged, Lord.
Along with 15, my lord, I think 18 may also be given. Same
Okay.
petitioner, my lord.
Let us understand this.
Yes.
Okay, 18.
My lord, in this application, my lord, we have challenged the my lord, order passed by the my lord, learned additional session judge, my lord. Where, my lord, this maintenance has been, my lord, arbitrarily, my lord. My lord,
125 or under section 125.
120.
Yes. What is the,
Trial court has given my lord maintenance of my lord 6,000, 2,000 to wife, my lord, 2,000 each to the 2 minor children. Then my lord, the wife preferred the my lord revision petition before the my lord session score. That her this maintenance is my lord not adequate. On that ground, my lord, that revision has been preferred, my lord. And then my lord, the learned additional session judge, my lord. Without my lord, any my lord, any improvement, any change of circumstances, my lord. That has been my lord, extended up to my lord 24,850, my lord. Almost 4 times. And my lord, learned trial court has come to a finding that it would not come to a my lord conclusion about the my lord, the annual income, actual income of the my lord husband, my lord.
what do you do?
My lord, my only prayer before your lordship, my lord.
What do you do as otherwise?
He is a my lord, he has got a-
Businessman, wholesaler.
Not he is a wholesaler, my lord. He is running a shop, my lord. Grocery item he is selling.
On page 37. Paragraph 5. Though it was an ex parte, it was
Yes.
an ex parte after your appearance.
My lord. He say expert, no evidence was.
No, it was an ex parte,
Yes,
but it was an ex parte order after your appearance and failure to file written statement.
that is there, man.
It is
That-
not ex parte simpliciter.
Yes, yes. Only thing is that. my
Then
lord,
now, how can you cry?
Only thing is that.
So far as final order is concerned,
Yes,
right? 125.
120.
Now revisional court, what did it do?
My lord, Lordship will kindly come to my lord, para my lord 12.
Seeking enhancement
Likewise-
perhaps. Seeking enhancement is also within the limit.
Likewise, our effort to ascertain the monthly income of the second.
On
party.
what basis court has passed the order?
Now, only my lord on the basis of our evidence and whatever my lord ascertain.
She adduced evidence
Yes. She-
earlier.
Yes.
So
Trial
there
court,
is-
she has adduced her evidence.
So it is not that without any material, the court
But
had
see-
enhanced.
Yes, man, she was not.
Question is
cross-examined.
about the justification.
Yes,
Materials were there, but
Yes.
whether there was justification or not, that is
Yes,
the
ma'am.
issue.
only from my prayer, my lord, from 6,000 to my lord, 24,850, my lord. Whether there was any, my lord,
You have-
evidence,
2 children.
yes. What you will kindly look at, my lord, para 12 at page 40, my lord.
Para 12,
At
page 40.
Yeah.
40.
Like. As your lordship got it, my lord.
And what is the other case?
Other case, my lord, there was a non-bailable warrant of arrest against me, my lord.
Why?
Because, my lord, I have not paid the, my lord, the maintenance money. Because of this amount, my lord, now I have to, my lord, flee away, my lord, leaving my shop and all, my lord. I could not carry out my business.
Impugn order.
Impugn order dated, my lord, 14/11/2024, passed by the additional session judge. He is a resident of, my lord, Titabar, the wife, my lord, presently residing at the unit.
Now pursuant to the original ex parte order,
My lord.
125,
Yes.
did you deposit 6,000?
My lord, by that time, my lord, she preferred this, my lord, revision petition for enhancement.
Whatever, but that was in force.
Yes,
Did you pay?
I think, my lord, there is a order, my lord.
It was delivered on 6/7/2023,
Yes,
right?
yes,
And thereafter, the wife prepared this petition for enhancement.
yes,
But that was not stayed 6,000
yes.
and that was not challenged by you.
I have not challenged. it.
So did you pay
My lord, only thing is
at
that,
the rate of 6,000?
my lord, in the other petition, lordship will just find, my lord.
Tell me. 6,000, did you obey or not?
My lord, some amount has been paid.
No, some amount will not do.
As per my instruction, my lord, totaling about 35,000.
Since 6/7/2023,
Yes,
did you pay?
some amount I have paid. my
At
lord,
least
but I-
you obey that part
Yes.
because there was no challenge from you.
Our case is that, my lord, till 23, my lord, on and off, my lord, she was with me.
Whatever, there is an order.
Yes,
On 6/7/2023, there was an order of 6,000 per month,
yes,
right? We are in exactly 2 years thereafter,
yes.
right? 6,000 into 24. How much?
About
Whatever.
1 lakh, my lord, 44
Whatever.
or something. like
Did you pay?
that. No.
And
About
that order was not challenged by you.
Not challenged.
Then
Because as this revision was challenged.
even
my
if we stay,
Yeah,
the criminal revision order enhancing the amount to 24,000,
my lord.
but 6,000 still remains.
But I am ready to pay that, my
You
lord.
pay that amount subject to deposit of entire amount from 6/7/2023.
My lord.
Within a period of 1 month, I am staying the revision order.
1 month.
That is the reasonable one.
My lord, and yeah,
You got 24 months. There was no challenge from you.
yes.
You agreed to it. So you have to pay
I am ready to pay.
6,000
I am ready to. pay.
1 month.
Only my.
You have accumulated for last 24 months without paying anything.
Because as my lord, this order was there, my lord. Amount, my lord.
You knew very well
Yes.
that it cannot be below 6,000.
Yes.
When the wife had preferred the petition, it would be either 6,000 or beyond 6,000.
But only thing in my lord, when this revision was there, my lord. So that, my lord, that 6,000 was not paid.
No, it is not the other side who had got the stay. It is not you who had got any stay order.
That is there, my lord.
The order was operating.
But only thing is, my lord, that
You pay take your instruction, 6/7/2023 up to this month, 6,000 at whatever area you have accumulated, you pay subject to that will read.
my lord, the annual income is about, my lord, 2 lakhs.
Show me the ITR then.
That, my lord, one,
Wife is claiming you are a wholesaler.
not wholesaler, my lord.
And from which place?
Titaborn.
You have kept your wife and 2 children in Dibrugarh and admitted them in private schools.
Yes. 23, my lord, up to 20.
So
I
it
was-
cannot be by any stretch 20,000.
What should we fix out the matter on Tuesday, my lord? I will have the instruction.
Because if show your ITR then, if you are really a retailer, not the wholesaler,
ITR is not.
you are running your business in Titagarh.
Titaborn.
You have placed your wife and 2 sons at Dibrugarh, admitted them in private schools, good schools.
Nowadays, my lord, everyone puts in private.
Yes,
school.
but cost.
No one goes to my lord.
So
government.
cost with 20,000, it is not possible. Rented house, 2 sons, wife, 20,000. With 20,000 income, it is not possible. In Dibrugarh, in Guwahati, I think 1 room will cost to 5,000 to 10,000.
That will depend, my lord, from area to area.
6,000 is bare minimum.
That is there, my lord. I am ready to pay that.
That is your, take the instruction, then we will keep the order of revision and the suspension and the other order. Otherwise, that was your duty to maintain 2 children and wife.
I agree.
That
I agree.
6,000 is very bare minimum. And that also you did not pay. So why should I? Court has to be pragmatic.
Tuesday next month, I will have the instruction.
Take your instruction. Wednesday. Okay.
Wednesday.
But 6,000 per month is a must,
Yes,
with no challenge from your side.
already instructed, my lord, that that money is. to be
Okay.
paid.
Mr. B.M. Chaudhary, Land Council for the petitioner, has sought listing of the case on Wednesday in order to complete his instructions. As sought for, list the case on Wednesday. 6,000 is must.
Yes, yes. I am obliged.
And if there are areas, 1 month.
Will be, my lord,
Take your instruction.
Can be extended, my lord, to.
We will find out the
my
flexibility.
lord, the next day. Obliged.
Oh, 18 is also same.
18 months are arriving
Wednesday.
at the same month. Oh, obliged.
May I please, your lordship?
Yes,
Lordship, there was an affair, my lord will find at page 14.
if you are so confident, go for ossification.
My lord, this. boy, my
This
lord,
is doubtful.
my lord, basing upon the school transfer certificate only. my
This
lord,
is Mr. Let us see your cost title.
my lord.
There is not even an alias.
My mistake, admit.
No. Apparent on the face of the record. And who is that? Nikibur Islam.
Nakibur Rahman.
Nikibur?
Rahman.
Hmm?
Nakibur Rahman.
No, no. Let us see the birth certificate or school certificate.
School certificate, yes.
Ah.
Page 8, my lord.
School
Page-
certificate,
Page
page
29, next to it.
29.
Yes, my lord.
Islam.
Alas, my mistake.
And learned trial court has observed.
My mistake. I am admitting.
Not mistake.
No, my lord, this is not intended.
Not a mistake. This is a judicial order. And still you have not been. Okay, that is gone.
I'm admitting my mistake, my lord. It should have been alias
That-
and Nikpur.
No, it was all throughout. It was all throughout,
Yes.
sir.
I
You
did not
started
notice.
the proceeding by filing petition on 30/10/2024. Come to page 30. Case put up today along with petition filed by
Yes,
Abdul Subhan, supported by so and so, with a prayer to allow Nikibur Rahman Elias
Alias
to go
Islam.
on bail,
yes, my lord.
showing cause on the date. So that cannot be changed. Court has observed. Let us see the order.
Yes.
Let us see the order.
Page 33.
Page 33. We don't find anything.
Here, my lord, the name of the accused has been reflected.
We
as
don't
Nakibur Rahman.
find anything. If I go on examining, then there something will be more adverse to you.
My lord, what I'm praying before your lordship, my lord, I may be allowed to just withdraw this petition with liberty to file afresh in the correct manner. my lord. That will be the best payment, probably.
Yes, Mr. I don't know what improvements council would make. Had Mr. J. Hamad and council put a petition. And this certificate was obtained after the commission of the offense.
19. Yes, my lord.
Trial court was benevolent enough not to observe that. But this court might observe.
Yes, my lord.
Be sure about it. And Mr. MP Goswami, Land Additional Public Prosecutor for the response number 1, from State of Assam. Mr. Hamad, Land Council for the petition submitted that the petitioner wants to withdraw the petition with liberty to file afresh with better particulars. Full stop. In view of the above submission made by Mr. Hamad, Land Council for the petition, this given petition is dismissed on withdrawal with the liberty as prayed for.
Undisputed.
Item 19.
Yes.
Lord, I have a small prayer. I lodged an FIR under the SC/ST Act. I availed a loan under the scheme of scheduled caste student. And in as per the terms of the
Was the FIR against whom?
against the director WBC department because of the some languages used against me. So the FIR was registered under the Atrocities Act, SC/ST Atrocities Act.
Okay,
The FIR was investigated and the final report was submitted.
okay.
Then I submitted my objection against the final report and by the order passed by the learned trial court. It was directed to investigate the matter again and to submit the report within a period of 60 days from the date of the order. The order was passed in the year 2022. But when after a lapse of 2 years, nothing was happening, I filed a petition before the court seeking a status report in terms of the order passed in the year 2022. So in the order, in the petition, the police official submitted that they have submitted a FR against the investigation and the investigation is completed. But so far as final report is concerned, no notice was issued to me.
That is the grievance.
Yes.
Hired Mr. S. Biswas, Learned Counsel for the petition, and Mr. MP Goswami, Learned Additional Public Prosecutor for the respondent state poster. Agreed by acceptance of the final report by the court of
This is Chief Judicial Magistrate Kamrup.
Chief Judicial Magistrate, Kamrup Metro, Guwahati,
Yes. That one.
submitted. Sorry, agreed by the acceptance of the final report. Submitted, submitted in connection with Dispur Police Station case number 4048 to 2021,
2021.
by the Court of Learned Chief Judicial Magistrate, Kamrup Metro at Guwahati
on 38/2024.
38/2024 without any notice to the petitioner. He being the informant,
Yes.
the petitioner has preferred the instant writ petition to assail such acceptance of the final report. Issue notice returnable on so and so as Mr. So and so. Case records, huh? Returned 4 weeks. Mr. Goswami has here accepted extra copy. Aru, the office to call for the case records of any case number?
GR case number is there.
Ah,
GR case number.
tell me
17856 of 2021.
where it is written, page.
Page 13.
Page
Yeah,
13 of the GR case number so and so, which arose out of Dispur Police Station case number 4048/2021. We can call for the case record, not scan copies, because it is closed already, right?
Or your lordship may direct the court to give us an opportunity to file our objection. That will also.
Let us
Yes.
have the records.
Yes.
Whether I'm entering my upset, person who will be agree whether he should be in party or not.
We'll see that.
20 seconds. Item 20.
Nowadays, I think against acceptance of final report, accused has the opportunity now. Perhaps examine B and SS.
Yes.
Yes, 20. Yes.
Lordship, my lord, there is a respondent has filed an FIR initially on 1/2/2023.
1, 2.
2023, my lord.
Respondent, who is the respondent?
Respondent minus is the lady, my lord.
Lady, okay, the lady. Respondent number, oh, sole respondent, okay.
She was alleging that I had some illicit relationship with him,
With her,
with her. my lord.
okay.
Yes, and give birth to a child. That is the case.
What is the affair?
FIR, you will also find at page. Starts on page 13.
And daughter of so and so.
You will go to that page.
Birth of baby boy,
Yeah, baby. Now, what?
yes.
During the course of investigation, my samples were also taken and it was found to about DNA. And that DNA report is also there.
Yes.
Now, case has been investigated, submitted charges under section 376. That is trial is yet to, charges yet to be framed. This case for consideration of charge. In the meantime, she filed another application under section 125. Relying upon the report of the DNA. Now my question is that since DNA report has not been legally proved in that trial, so for session case is concerned. So that cannot be taken into consideration in the section.
That's for the trial court.
Yes, but while court, I have made an application before the trial court. Or that report cannot be there, but trial court has primarily come to find, yes, that report can, that's fine.
Which is the order?
That your lordship, that is in order, your lordship will find at page 6, Annexus 6, page 31. Last portion, my lord.
A detailed judgment has come. Let me examine that DNA also.
DNA, my lord, after all, DNA report has been legally proved in that session case, man. Whether it was correctly obtained or not, whether
But-
samples were collected, change of custodies are there, many things are there.
But it is matching.
One part is missing, they say. Whatever it is, but it has to be legally.
No,
proved.
it is also laid down that it is, Supreme Court has also said that under section 293, submission of the report itself is enough.
No, my lord. Recently.
Non-examination.
No, no, no.
Examination is not required.
No, my lord, here your lordship, I have got a decision, my lord, Justice Mehta necessarily. A death sentence has been set aside. On the ground that DNA simply exhibiting a DNA will not prove. The
But
contracts
there-
have to,
Maybe,
in
I don't know,
2025.
but maybe there are other decisions.
Recent decision, 25.
But then what are the other decisions then?
That have been considered, my lord. Death sentence has been set aside, my lord.
Okay, you give it to me, then we'll see. Without reading, they will not pass in
Yeah,
your,
I'm only saying that the DNA report may not be taken into
no,
consideration.
we'll have to see.
That is only my point.
This is always subject to correction. We cannot readily agree.
Yes, my lord.
This DNA thing is new.
New, and
Yes, mister, you examine. though you are not a party, but DNA issue is always of importance. We'll examine this. Today, I have some difficulty.
I'm only prayer that
We'll keep it in motion only.
DNA report may not be
Next.
taken. That is my only prayer.
We'll examine to that.
Because it has to be legally proved, my lord. But that is.
Where is your case? When is your case? Next date?
It has the case in Bongaigaon, my lord.
When? Next
Next
date?
date is 37.
37 will be difficult. Sir.
Now let him proceed, my lord. I don't have the stay of the proceeding, my lord.
Ah.
Only DNA report may not be considered.
Okay, we'll examine that.
That part. Only. Because your lordship will see my prayer also, but I'm not talking out the 125 property. Because if she is entitled, she will get it, my lord. But DNA report may not be taken into consideration. It has not been legal. That is only my.
Mr. Korogi, can we propose on 13th August?
30th of August.
13.
13 August, yes.
We'll post it in motion. Just not hurry. If DNA report should not be taken into consideration, should not be taken. You go through it.
I will supply a copy to you. Along with the job.
Heard Mr. P. Kotoki, Millennium Council for the petition, post of, having regard to the issue involved, this court has also sought assistance of Mr. M.P. Goswami, Land Additional Public Prosecutor, to render assistance in the case. Post of lays the case on 13/8. The name of Mr. M.P. Goswami, Land Additional Public Prosecutor, be reflected in the response side in the cause list. You get a copy. Please furnish me a copy.
That's a regarding whether that part the DNA goes, otherwise by law, 125 proceeding by law.
125 proceeding, it is not a summary proceeding.
I understand, that's why.
Very, when it goes, it's finality is not attached to.
DNA report is not attached, nothing that.
No, finality, any proceeding under 125, no finality is attached.
No finality attached, but still, but.
This is summary
report-
kind of procedure.
Which is subject matter of a session case. That is my, demand is that.
No, that any observation made in 125 cannot influence the sessions
I
court.
understand, by law, but whether that report can be taken into consideration, that is the another statement. When it has not been legally proved.
But question is about maintenance of a baby also.
I understand, my lord, whatever it is, but that I understand.
No,
but-
I am not observing anything. On 13/8 we will decide this way or that way. Because there you go through the binding directions on DNA.
Yeah,
Supreme Court has recently issued about
Yes, I understand.
one week back.
the chain of custody.
Yes.
Yeah, that I understand.
That has to be examined also.
That has been examined, I understand, but they will subject to process definition. If that is
But
not, done,
otherwise it is perfect science.
but there are loopholes. Regarding-
No, regarding handling is loopholes.
And also the,
Not on DNA report.
your lordship may kindly see the judgment that has been decided. That
No, we'll have to waste time today.
Yes, will analyze his part.
Actually, I'm in a hurry. Yes, Mr. P. Bora, Pran Bora is available. Madam, today will not be possible. Next Thursday we'll take up. Right, your case. Thursday को लेंगे. Huh?
Lordship has a partner matter.
Yes, partner मेरा लिख लीजिए.
Post.
Yes.
This is a quashing petition, Quashment, I'm seeking a quashment of the charge sheet against the petitioner.
Offense,
Offense is 498A. The mother.
you are
I am the mother-in-law.
mother.
Yes. My lord.
Trial is going on.
It's yet to begin, my lord. I am yet to appear.
Yet to begin.
Yet to begin.
Okay.
My lord-
Will not pass any observe on Wednesday will take. I am actually,
Oh, no, no problem.
okay. Trial is yet to begin. If
See,
the mother-in-law,
I'm the mother-in-law.
okay, we'll
My lord,
examine your case.
Next date is on Tuesday.
No, trial is yet to begin, you said.
I'm yet to appear. On Tuesday, I've got the summons.
You
to
see
appear.
an observation case is pending. I pass the order.
Yes,
Mr.
J. Bora.
J. Bora, heard Mr. J. Bora, Learned Counsel for the petitioner. And Mr. M.P. Goswami, Learned Additional Public Prosecutor for the respondent number 1, Constable Assam. First of list the case again on so-and-so in the motion column for further consideration. Wednesday.
22.
Karim Ali. Yes.
Please, your lordship.
What? Passing?
Yes, your lordship.
What offense?
Offense is not so grievous.
criminal trespass, theft, so on.
Why you have come?
Your lordship, the respondent number 2,
Is it at what stage?
it is in the trial stage, evidence before charge. Cognizance has been taken.
When is the next date?
Next date is on 2nd of August.
Okay, Wednesday. Wednesday. This Wednesday, before 2nd of August. Next, Mr. Asur.
Yes, sure.
Okay. আগৰটো নিচিনা কি দিব? Asur খালি লিখিব। Huh?
Item 23.
Yes, what?
Worship on a very narrow compass, Your Lordship.
Narrow compass, what bulky brief? Huh.
Your Lordship may take it up on Wednesday, then Your Lordship.
With D. Bora, Central Government Council.
No, Your Lordship, Senior Standing Council, DRI.
Senior Standing Council,
DRI.
DRI. Okay, DRI. Place the case on Wednesday in the motion column.
25.
Yes, sir.
Lordship,
Crossing.
Yes, Lordship.
Which trial is there?
Yes, Lordship.
When?
On 25 and on next.
When is the next date?
Yes, Lordship, next date is 25. Lordship.
Huh?
25. Lordship. 19/8, Lordship, sorry.
19/8.
19/8, Lordship.
Okay, 1st of August. Friday. Mr. N. Rai.
Yes.
Okay. MP Goswami. Friday. Good.
For admission, item number 27.
Yes, sir. Anything urgent?
But only the person has to appear before the trial court.
Huh?
Person has to appear before the trial court and he's convicted in fact, Lordship.
Criminal appeal. What is criminal appeal? Conviction. Against conviction.
Against conviction, Lord.
Huh?
Lordship, what has happened? There are major contradictions and in fact.
No. This is an appeal. He is yet to be admitted.
Yet to be.
What is the offense?
Well, it's section 8 of the POSCO Act. He was convicted.
POXO Act. And for what? Period?
Lordship,
is for minor 3 years.
3 years and 6 months simple imprisonment term. And in default of payment of fine.
Who is that? Paragraph?
First title.
Now, in the first title, page number 2, have the description. Lordship.
Convicted 8 under section 8. Will admit this
Yes.
only for admission today.
Yes, for.
This is statutory appeal.
That is a-
Statutory.
Had Mr. Oh, we cannot stay the operation.
So we'll have to appear. and-
No.
It's a-
Mr. Betala. It is stay or suspension of execution of the sentence. Otherwise, to stay the operation of the judgment means stay of the conviction. And for that, you have to meet a much higher standard.
If I can.
And for suspension also, interlocutory application is to be filed.
So we.
It is unlike revision.
Lordship.
So if you file it by, say, tomorrow, if it is a working day, we can post it on Tuesday or Wednesday. Then only we can, otherwise stay this, where is stay the operation of the impugned judgment means stay of the conviction.
Conviction. I think. So in that case.
Only politicians need it. Right, Mr. Borua?
Let's say file it on Monday.
We file it on Monday. Mr. Betala, Land Counsel for the appellant has submitted that he is an interlocutory application under section 420, right? 430 within bracket 2. BNSS is going to be filed on Monday. Post of as sought for release the case on Thursday.
And the.
Item 28.
Next date.
If I appear for the.
Yes, madam.
Lordship, meeting matter be taken up after the break. Your Lordship, might.
No, after the break, I'm not sitting. So Monday or Wednesday? Wednesday. Wednesday, right? Miss
Barsha Gupta, B Gupta.
B. Colita. B or D?
B.
B. Okay, on the request from Ms. B. Colita, Learned Counsel for the petition, is the case on Wednesday, Mr. D. Bora, Learned Senior Standing Counsel, DRI. Okay, is present. For the respondent number 1 is present. The name of Mr. D. Bora, Learned Senior Standing Counsel, DRI, be reflected in the response side in the court list. Wednesday. Wednesday.
Item 31.
No, I took to go to Thursday to hearing to off. Order. To order to Yes, Mr. Oh, appointment of amicus. It was Thursday. There is no representation on behalf of the parties today on call, though Mr. RJ Burwa. Yes. Though Mr. RJ Burwa, Learned Additional Public Prosecutor for the respondent number 1, State of Assam is present. In view of non-representation on behalf of the parties today on call, there is the case on Thursday. We'll dispose of 2024 matter. The court is not sitting on second one.